Generally, precedents are two types. One is authoritative precedent and the second one is persuasive precedent. Regarding authoritative precedent, those precedents are bearing binding forces. It means any decision settled by the superior court and those rules, guidelines, or principles as declared and settled in those decisions, the inferior courts in the jurisdiction of the land are bound to follow. They could not skip those rules, principles, or guidelines settled by the superior court. But in case of persuasive precedents, those precedents are not binding force. So, for example, in case of India, a high court has both authoritative and persuasive precedent within its jurisdiction. So, in case of authoritative precedent, all the inferior courts within the jurisdiction of the same high court are bound to follow those rules, principles, and guidelines settled by that high court. But in case of persuasive precedent, one high court's settled rules, principles, or guidelines could not be binding over the other high courts within India. Suppose, for example, the settled rules, principles, or guidelines of Bombay High Court could not be binding upon other high courts such as the Madras High Court or Calcutta High Court or Odisha High Court, etc. So such kind of precedent is considered as persuasive precedent for those high courts who are not bound to follow the settled rules, principles, or guidelines made by another high court, because that high court which settled those rules, principles, or guidelines are only applicable within its own jurisdiction. So its jurisdiction is confined to that particular state's territory, but it would not be applicable to other high courts as they have their separate jurisdictions.